Welcome back, everybody, to our second module in our EB-5 series. If you missed the first one, you can click on the link. We've got links here that ensure that you don't miss anything, and if you're jumping in midstream, you can go back and see some of the earlier ones. In our first module, we talked about the program in general and what the role is and the importance is of regional centers in the whole EB-5 process. And in addition, we talked a little bit about AmLaw Group ourselves and how we distinguish ourselves from other law firms. In this module, the second part, we wanted to talk a little bit about what the process consists of and how we work with our clients in going about moving things forward. Let's say we've reached an agreement, signed all the paperwork, ready to get started. What does this whole process consist of, and what do you need to focus on? Now, I would say, and if I had $1 for every time I said this, I would have retired 20 years ago. I always tell clients, and believe me, this applies to you, everybody out there watching this. The biggest challenge of the EB-5 process is doing the source of funds work. That's at the first stage when we're filing for the conditional green card for the I-526. You have to detail and confirm where you got your money from. Easily done, right? People say all the time, oh, when I open my bank accounts overseas, they do due diligence on me, I can provide that same information. Or they can say, hey, I've been working here in the US for the last 10 years on an H-1B, everything's straightforward, that should be really easy. The reality is 9 times, and I would say 9.5 times out of 10, it is much more difficult than our client expects. And sometimes it's even more difficult than we expect. Because when we speak with the client initially, we're making a decision to move forward just based on initial discussions. Usually clients do not present to us all their paperwork when we have an initial discussion prior to signing the agreement, because once they send us the paperwork, we've got to start reviewing it, analyzing it. That takes man hours and work, and that's already part of the work. But we always make sure we have at least a pretty good detailed conversation before signing on a client to make sure, at least verbally, we have a good understanding of their source of funds and the path of funds, and we feel comfortable that, yeah, we should be able to make a good case. Now, the problem is, and again, why is it always more difficult than clients anticipate? Because USCIS is so arcane and ridiculous, I would say, in terms of their demands, that's what makes it so difficult. I mean, their demands exceed common sense. Their demands exceed what a normal person would generally expect would be required to show your path of funds and your source of funds. Fortunately, until you start living in the EB-5 world like we do, you don't understand how difficult it can be and how ridiculous sometimes the government is. So again, no fault of our clients, no fault of yours that we have these complications. It's just the way it is. So what is it that makes the process so difficult, and what do you need to focus on? We could even take a very easy example. Let's say you've been in the US for the last 10 years on an H-1B. All of the funds that you're going to invest were generated directly or indirectly by your work here in the US. So you had salary, savings, maybe you invested those savings into some real estate, sold the real estate, but let's make it simple. Most of your money, if not all of it, was just your salary and the savings, maybe some investments you made. You accumulated $800,000. It's like it's pretty straightforward. In reality, it could be and should be, right? Especially with salary. Salary is the easiest source to use generally for an EB-5 case to prove your source of funds, provided the investor or his direct family does not own the employer. So we're assuming this is a third-party employer, no relation to the investor. Salary is generally the easiest way to prove it, but it's not always easy as, per se. Why is that? Let's say you've been working for years and years, you've saved up, $400,000, let's say. You send us your bank statements with, bank statements and, shows a balance, money goes up and down, but generally it's going up and up and up. And let's say even as of today, you can show that $400,000 you've got in your bank account. Excellent. But when we start looking at it, we might start seeing things that could pose challenges. For example, so you'd have expenses. You didn't save everything that you earned. You had to spend some money. Maybe you spent a lot of that money that you had saved up, but you had recovered it. I don't know. Let's say you sold a car that you had owned. I don't know. Or your brother owed you some money, and he gave you back $100,000. Or your parents sold real estate and they gifted you the sale proceeds of that. So in reality, that $400,000 might not solely be from your salary. It could be a result of these other transactions, a gift, sale of real estate, sale of property, earnings from maybe some investments you made before you came to the US. And the problem that can arise in that situation is if the income from those other sources was mixed in with the same bank account that you were using for your salary and savings. The problem is we've got to go back then and prove where all of this other money came from, in addition to your salary and the savings from your salary. So let's say your parents sold their house overseas and they wanted to gift you that $100,000 coming in the bank account. The government's going to say, wait a second here, we see you have $100,000 coming in, you're going to have to prove the source of that funds. And you might say, hey, don't pay attention to that $100,000. We don't even need that for the EB-5. We've got more than enough money just looking at our salary. But the government says, hey, money is fungible. It just all gets intermixed together. You can't separate it. So once money comes from a different source, in a sense, it almost spoils or taints the money that's in the bank account that you wanted to use. And so this is where we often see problems. In the EB-5 world, it's called co-mingled funds, right? Co-mingled funds, the problem of co-mingled funds. That when you've got money that you can source, account, but in addition you have money that came from some other sources and you're not planning to use those other sources and you can't even prove those other sources, how that money came about or whatever. You can't just arbitrarily say, well, yeah, we did get this other money in that bank account, but we're just going to choose to ignore it because we have enough from, say, my salary. It just doesn't work that way. So even in easy, straightforward situations where the client just had a job, earned money, used that for the EB-5, if you've got other sources of income coming in, that can create problems, definitely. And so that's something that trips up a lot of clients, if only because you never think about it, right? I mean, just think about it. Yeah, your aunt, Aunt May gave you $50,000 as a wedding present 5 years ago. This is stuff that sits in people's minds, years and years after the fact. And so when we go through the bank statements and start reviewing stuff, where problems can arise. So that's just one example of the problems that can arise. Another common situation that comes up is the lack of documentation. And this is a problem too, because we have to go back a lot in time. I mean, just by default, regardless of what your source of funds is, by default, you've got to provide your tax returns for the last 7 years for yourself personally, as well as any entities in which you have any holdings, assuming it's not a public company, although they could get that public information as well. But any kind of private companies that you might have any holdings in, you've got to provide the tax returns for the last 7 years, regardless of whether you're planning to use income from those entities or job for the EB-5 process. But in addition, we've got to provide documentation that substantiates everything that's in the petition. So what does that mean? Let's say you've been working at your job for 10 years. Yeah, we've got to go back and show pay stubs going back 10 years. We've got to get bank statements going back 10 years. That can be difficult. And I'm not saying you need to have all your bank statements for all those years or all your pay stubs, but we have to go back and at least show enough and go back far enough in time to convince the officer by a preponderance of the evidence that, yeah, this guy's story is true. He's not making it up. He's been working at IBM the last 10 years, et cetera, et cetera. So that's the other big problem that can arise when we have to go far back in time, is getting the needed documentation to prove our client's case. Because the farther back you go, generally, the more difficult it is to collect the needed documents and provide all of that. Now, what happens if you don't have that? And I don't want to go into too much detail here, but I just want to say it's not all lost. Let's say, hey, I don't have bank statements from 10, 15 years ago when I opened my company. It's a challenge. It's a bit risky, but we've had cases that have gotten approved. And to be honest, I don't think we've ever had a case denied because of that. But you're just going in there with more risk, and you have to provide secondary documentation, like secondary evidence that somebody could confirm that, hey, back in 2012, you had earned, X amount of dollars and put that into your business and stuff like that. It could be a business partner that could write an affidavit, could be a relative, could be somebody else. But just keep in mind, if you don't have the original documentation that we need, there's always a heightened risk that there could be some questions or problems. Obviously, we collect as much evidence as we can to overcome those doubts that an officer might have. But again, you're running a slightly higher risk that there could be doubts, questions that could lead to a denial in cases like that. So how does this all translate to putting together your case? Let's say you've found your attorney, hopefully it's us, and you're working with them. You say, okay, guys, what are the next steps? How do we put this all together? So as I mentioned a little bit earlier, we have that initial kickoff call where we, after that kickoff call, we create a list of documents which will reflect what we need from you based on our initial conversation. Now that list could change over time. As you send us more documents, and we might realize, ooh, this isn't what we were exactly hoping to receive. We might need, documents XYZ in addition to what we asked for, just because of some of the deficiencies in the documents you're able to provide us. Each case is individual. That's why I can't go and make generalities, but I hopefully gave you a taste of what generally is kind of required. Now, one question that comes up is, does it matter if the money's in the US or overseas? Doesn't matter at all. As long as you can get the money here to invest it in the project in the US, doesn't matter whether it's in the US or here. Generally, it's maybe better if it's in the US, if only because compliance requirements are a little bit higher in the US than most other countries. So if your money was being earned here and stuff like that, generally clients have been more compliant. It's easier to put the paperwork together. But again, that really depends on each individual client. Does the money need to be accumulated already at the time when you start working with your lawyer? No, it doesn't. And in many cases, our clients have not accumulated the full $800,000. They might, in theory, have the money, but that might require them selling a house, selling some securities, maybe borrowing the money. So you don't necessarily need to have all the money saved up in a bank account when you come to your attorney to start the process. But we do need to have a good game plan. And that's where that kickoff call comes into place, where we go through, okay, what do you have right now? What are you looking to get in the future? And if you don't have everything, what other options are you planning to use? So again, you don't have to have everything in place, but we need to have a plan as to when it's all going to get in place and what the sources are from. Because what those sources would be obviously would affect our work as well and affect what you'd need to get together for us as we put together all this paperwork. Now, you can use a number of sources for your funds, and there's no limitation how many sources you use, although I have to admit, if you get over 3 sources in a petition, you're probably pushing the patience of the officer. We've had cases with more than 3 sources of funds, and they all got approved, but you're running the risk of possibly confusing the officer, because if it gets too confusing and they don't really understand something, it's just really easy for them to say, forget it, an RFE or maybe just a denial. So when we're working with our clients, we try to, it's the KISS strategy. Keep it simple, stupid. So we try to reduce the number of sources of funds we're using, and we try to use those sources of funds that are most transparent, most straightforward, and most easily explainable. And as I mentioned, it could be a loan, it could be from a will from your parents, it could be sale of real estate, salary, stuff like that. There's almost an unlimited number of type of sources that you can use. And we would have to go through the source of funds analysis in showing how each one how that money was all earned. Now, one thing I wanted to make a focus on, an initial focus on, is what is involving sale of real estate or earnings from a business or the sale of a business. In both those cases, you need to show how and where you got the initial money to buy the real estate or to open the business. Now, if you're buying real estate, you had a mortgage, chances are you didn't have to put too much money down. So that makes the challenge a little bit easier. But again, if this was 20 years ago and you have to prove where did you get $25,000 20 years ago, that might be a problem in terms of documentation. The same goes for when you're selling a business to use it for the EB-5 or when you have dividends from a business. We have to go back and show, okay, how did you get your money to acquire the shares in the business? Or when you opened the business, how much money did you put into it? Now, if you had a purely services-based company where you didn't have to put much capital in, you just had a laptop, you opened up your doors and you started offering services, clients prepaid you for the work, so you didn't have to invest any money. That's perfect. I mean, that's an ideal situation. Unfortunately, that only covers a small spectrum of our clients. So most of our clients put some amount of money in, maybe to buy inventory, maybe to buy equipment, other capital needs. And so we have to prove where the money came from to make those initial investments in the company. And again, depending on the client's situation, how far in the past it was, et cetera, that might or might not create complications. So hopefully this gives you a good taste of source of funds. Here's one other thing I wanted to say about source of funds before we talk about the next steps. And this is a really important topic that is very relevant right now at the end of 2025. Borrowing money. And we should even create a separate title, a little focus on this, and in the description we'll talk about this, because borrowing money, super, super important topic right now for the EB-5 program. So there was a court case about 5 years ago that came out where the federal court indicated that you could use borrowed money for EB-5. And if you borrowed that money without collateral, there was nothing for you to prove, right? You borrow the money, it's as good as cash, you put it in the project, analysis is over. Now, if the person who was lending you the money was not a bank or a similar financial institution, then the person or entity lending you the money would need to prove where they got that money from. So if you borrowed the money from your friend, he loaned you $800,000, your friend then would have to go through the full source of funds analysis and prove where he got his money. But if the person or company lending you the money is a financial services institution, a bank, a credit union, or some other institution that's in the daily business of lending and borrowing money, then the government has said, hey, you don't have to prove where your money came from because this is your business. You're in the business of lending money. So obviously in a case like that, if you're ever borrowing money from a bank without security, it's a very easy analysis. The bank is in the business of lending money. They lent you X amount of dollars. You provided no security. It's very straightforward. Very few banks, however, this is no news to most of our viewers, very few banks will lend you money without collateral, without any security, right? So if it's a HELOC, they put a lien on your house. You might get other personal loan that's maybe secured by assets that you have or other real estate. So if your loan is secured by other real estate or assets, then you need to prove to USCIS, where did you get the money to buy those assets that served as security? So in a way, if you borrow money against assets, you're still doing the exact same analysis as if you were to have sold that asset and used the sale proceeds for the EB-5, right? So imagine you had a house, you sold the house, the government's going to say, show us the money to buy the house. If you borrow money and secure that loan with the house, you're going to have to still provide those same documents. So I guess in a case where you don't want to sell your house because the market's really bad or for other long-term reasons, you just want to borrow against it, from a USCIS perspective, it's still the same paperwork that you'd have to get together. So that's what happens if the loan is coming from a bank or financial institution. If it's coming from a friend or a relative, then that friend or relative has to provide all the documents as if they were the investor for the EB-5. And we regularly do that. It's quite a common practice. Now, here's one thing to keep in mind. If it's a friend, we always structure it as a loan. If it's a relative, it's just easier to do it as a gift. It looks very suspicious if a friend decides to give you $800,000. That's pretty suspicious. Loaning you, yeah, sure, maybe that makes sense. And if it's a relative, again, the relative might lend you the money, but it's just a little bit cleaner and easier with paperwork if we instead structure it as a gift. And we can go into those details in a personal consultation with you to discuss, why we do it that way, etc. But here's a recent event or phenomenon that has occurred starting maybe late 2024. And it's just taken a slight turn of events over the last couple of weeks that is affecting, I think, a number of investors. Regional centers started lending money maybe in late 2024. And so I think it was a great option. It was a great opportunity since it opened up a lot of new options for people who otherwise couldn't afford EB-5. A lot of investors might have saved up $400,000, $500,000, $600,000. They just didn't have the last $200,000 or $300,000. But if the regional center would loan them the money, then that would be a readily, easily option to participate in the EB-5 program. The terms for these loans from regional centers really vary from anywhere from 6% per annum to maybe about 10%. And I'd say the average is somewhere in between 7 or 8%. Sometimes they charge an origination fee. So an origination fee is a one-time fee that they charge just for setting up the loan. And that origination fee could be as little as maybe 1 or 2% or as much as 5%. And the loan amount varies by regional center too. Generally, I think the max is between $250,000 and $350,000. So depending on interest rates and whether you have a home or other options for lending, regional center loan might be the way to go. Here's what you need to keep in mind. As of September, early October 2025, a number of regional centers were getting NOIDs or even outright denials for investors who were using financing structures with their applications. I'm not personally familiar with the structures. I haven't seen the deal documents for these regional centers that had these denials, but it goes to show that you need to be very careful when you hear people saying, hey, we're a regional center, we're offering loans. It's a great opportunity. It's something that can be very valuable for people that are just short of having that full 800,000, but you need to be careful and do a good review with your attorney as to the loan structure and how it's set up. Because like I said, there were a couple of regional centers that had some very serious problems, how they set up those loans. Fortunately, we had no investors in those projects. I didn't see the actual documentation for the loans, so I can't assess, how problematic those loan structures were, but that's just something to keep in mind because a lot of our clients, especially a lot of our clients that are in H-1B status in the US lately, are looking at these regional center loans to help get them over the hump to 800,000, but you do need to be very careful. Again, if you do have another option, such as a HELOC or getting a second mortgage on a house or some other real estate, generally speaking, that might be the safer route to go. But if you just don't have access to other assets that you could use as collateral for a loan, regional centers can provide the loans, but it's something you need to be careful and work with your attorney on before you actually make the final investment. So after all of this analysis with the source of funds, and assuming you've gotten everything together, how we generally work with our clients is once we've worked far enough with the client that we can see the light at the end of the tunnel, we've collected enough documents, we've worked through the strategy, and we feel, yes, everything's under control, everything's good. Might take another 2, 3, 4 weeks to get everything done or for the loan to close, etc. But once we feel confident that everything has been or will be proven to our satisfaction, we'll tell the client, hey, you might need to go out and select the regional center and select a regional center project. So that is the focus of our next episode for the third module in our series, where we're going to talk about selecting projects, how to go about selecting projects, and the timing and the timeline for investing. If this was helpful for you, please reach out to us if you'd like any kind of personal attention, a personal consultation, or to discuss your EB-5 plans in particular. We'd be more than happy to work with you. Otherwise, stay with us or click on the link below in order to get access to the third module in our series.